Hi, friends. Welcome to episode 358 of School Librarians United. I am your host, Amy Herman. This podcast is dedicated to the issues and challenges school librarians face every day. As a school librarian in my 19th year, I knew I wanted a podcast which addressed the nuts and bolts of running a successful library program. I don't claim to have the answers, but I hope that this is a platform to share resources and exchange ideas. Now is a perfect time to mention that all the ideas and opinions expressed in this podcast by myself, my interview guests, and listeners who reach out to the podcast are our own and do not reflect those of our school districts. When incorporating research, I always make sure to cite my sources. So whether you are a novice or a veteran school librarian, this podcast has something for you. I welcome you and all listeners to reach out with your feedback and episode suggestions. You can reach me on Facebook, on X, formerly known as Twitter. My handle is at @LMS_United. On Threads and Instagram, you can find me at School Librarians United, and on Blue Sky at SLU Podcast, or the email address schoollibrariansunited@gmail.com. If you include your mailing address, I'll be sure to send you a podcast sticker. And now for today's episode, student privacy and my conversation with school librarian and Law for Librarians trainer, Heather Hornor. Heather Hornor, welcome back to the podcast.
Thank you so much. I'm so excited to be here again. Thank you for having me.
You know, we met just a month ago. You contributed to the Conflict Resolution Experts Chime In episode. So friends, for those of you meeting Heather for the very first time, Heather, would you please introduce yourself, tell us about your library, and a little bit about your work schedule?
Yes. So my name is Heather Hornor. I am currently a high school librarian in Portland Public Schools in Portland, Oregon. I think I said I was high school. I've been a librarian for 18 years, and I've done elementary librarianship, high school librarianship, library administration for a few years. And I love what I do. High school librarianship is the best job out there.
Well, this is my year 5 in high school, and I have no intention of letting go of this job. I will work here. And it's fun because really sort of I'm digging in and planting roots because for the first time in my career, I don't want to go anywhere. Like this is where I plan to retire. The state of Michigan says I can retire in 2033. I don't think I will be. I think I'm going to keep on going for a while. I don't know. It changes everything when you can bring your dog to work every day. All of a sudden you're like, oh, this is fun. And it's not just about the dog, friends. It's not just about the dog. We are here today to talk to Heather about her expertise in student privacy. And you had an opportunity which a select handful of librarians around the country have been able to learn and engage with student privacy and how school librarians are ultimately going to protect our students when it comes to the content which they are learning about and researching. But let's go ahead and get started. How did you become a Law for Librarians trainer? Because I remember hearing about this back in 2024 because Molly Detman and Kathy Lester were also talking about becoming Law for Librarians trainers. And it's something that I really am hoping you'll give us a bigger picture.
Yeah, so the current chair of the Texas Association for School Librarians, the fabulous Brooke King from the Houston area, reached out to me and asked if she could nominate me. I did not hear about this at all, so she asked if she could nominate me, and I said sure. And then she and I actually went to Chicago with a couple of other people from Texas in May of 2024, and it was a fabulous experience.
Well, and let me ask you, because it sounds like you really were able to give a great deal of focus and attention to how we do this at our school level and our district level. But can you give us an idea of what the training entailed? You were in person. What does that mean now that you are a certified trainer in the Law for Librarians?
So we had a very, very intense 4 days with lawyers from each personal area that we learned about. So we learned about copyright, we learned about privacy, we learned about intellectual freedom, we learned about social media and how to handle all of that. So these were all super, super intense days with so much information. But the best part was that we got lawyers who actually practice this law, oftentimes in front of the Supreme Court, who are experts on the laws that govern librarianship. And it's not just for school librarianship, but also for academic and public. And it was a total watershed of information. But fortunately for us, they had a space set up for us. So when we all started to train, there were usually anywhere from 1 to usually 2 in Texas's case, because that's where I used to live. And because we're so big, we had 4 people. But we had this space where we could ask questions of OIF as well as the lawyers who trained us. And then we all just kind of started supporting each other as we started to train. And that still continues to this day.
Like a lot of trainings, sometimes we just we sort of compartmentalize and we're like, oh, that's a just in case. But it sounds like this is the kind of training that you are going to keep with you, and you are going to find yourself calling upon the when it talks about the protections for student privacy and intellectual freedoms. And it sounds like those kinds of things, they're not parked in the back and you're just going to call upon them when needs be. It sounds like this is something that really has sort of transformed how we should run our libraries, and do so keeping in mind our students' privacy.
Well, and we also are charged with presenting at least twice each year. So because we are required to present at least twice, doesn't matter the group, we continue to get that information and updates about lawsuits and all these different things. And so, yes, it's a very active participation and active fluid thing that's going as we continue to train.
Does this count as a training?
Sure. I'll probably put it in.
Absolutely. Well, and you know what? It is on demand. It's on demand training. You've got an international audience. This is fun. Okay, so yes, true to so many of us, friends, we learn on behalf of others. We always are sharing what we learn and passing it along to the community that we support. But today is our opportunity to be trained by a Law for Librarians trainer on student privacy. And I'm so grateful you're here. You did start your presentation with a disclaimer, and this is really important.
Yes, and this is something that ALA told us we needed to do. The lawyers told us we need to do this. Anytime you're talking about legal information, doesn't matter whether you're an expert or not, you always need to make sure to provide a disclaimer of saying, I'm not an actual lawyer. This is information I have been given. If you have questions, you need to consult with an actual lawyer. And it's just, I'm not a lawyer. I'm presenting on information that lawyers have given to me, but I'm not qualified to give legal advice.
Well, and forgive me, but I know that a lot of districts have retained legal representation. And I know that most large school districts do have legal representation. They have lawyers which do review some of the things that they have to work through. And it's not unusual for a district, when they are confronted with legal issues, to call upon the lawyers that they have retained.
That is correct. But there's tons and tons of sometimes suburban large school districts that contract out. They don't have an in-house legal representation. Rural districts often have to contract out if they choose to. So it really is kind of across the board as to whether or not your school district has legal representation, and if those lawyers work on a regular basis with that school district. That's something that I have learned over the past couple of years, is not everybody has in-house legal counsel.
One of the criteria for being on the show is, what are you going to share with listeners that they can do some of their own deep dive after our conversation is finished? And you were incredibly generous to share with us the training materials that you provide when you do your presentation. And so I'm very excited anytime somebody creates a presentation that they then turn around and say, oh, here you go. This is something that you can do that deep dive. It has your contact information on it. But thank you very much, because this is one of those things where I think, given the detail in which we're going to go into, it is awfully helpful that you have also included your training materials as well.
Yeah, no problem.
Okay, cool. The slide deck you shared jumps right into data privacy, and in this case, the guidelines for student data in a school library. And I'm wondering just how much this overlaps with patron data at a public library. Are they basically the same, or am I oversimplifying?
I think that the general application of privacy, like if you're looking at from a very general perspective, it is very much the same, but how it is actually practiced really depends on each organization, to be quite honest. And it really depends on each state's privacy laws and application of the privacy laws that we have that govern this. And so it's probably when you really get down to the details, that's where it can vary. So, for example, how long do you hold on to student records? One school district may have a different policy on how long they held on to those, and each public library system might have their own policy on how long they hold on to those. So, yes, general application, yes, same protections, but how it is executed can be vastly different.
Got it. Okay. So in this case, your recommendation is that we need to do some of our own homework and look into that ourselves. Would that be at the district level? I mean, what would you recommend? I live in the state of Michigan. I don't live in Oregon. So if I needed to learn about the privacy laws here in the state of Michigan, I would do that investigating it at my district and at my state level.
Okay, so this is what's really, really interesting is that privacy laws are in the U.S. are a patchwork of various local, state, and federal laws that have been established over the centuries. So we first had a writing from Warren and Brandeis. This is from a Harvard publication back in 17 something. I don't recall exactly when it was. Sorry, 1890. And basically, Samuel Warren and Louis Brandeis basically wrote this paper from the Harvard Law School saying, hey, we believe that humans have the right to be let alone. Okay, so that's really what kind of started the concept of what American privacy looks like. So that's quite late in the game, considering that other countries, so say, for example, in the EU, their privacy protections are really, really, really tight, restrictive, and it is very, very difficult to get personal information. Whereas ours, we were very late in the game. And then finally, you have Alan Weston, who basically expounded upon this. He wrote for the Washington and Lee Law Review. He basically said, and he stated this in 1968, that individuals, groups, and institutions get to determine for themselves when, how, and to what extent information about them is communicated to others. So again, I feel that 1968 is quite late in the game in terms of privacy. So the ones that we're probably most familiar with is FERPA, obviously. That details who can request student education records. But the interesting thing about this is that the way that FERPA is interpreted really changes from state to state and their sunshine laws. If you don't know what sunshine laws are, it's basically from FOIA and how the state determines what is public information and what is private. So, for example, in Texas, where I used to be, FERPA and student records, because the Texas Constitution is so strong on parental rights, and it always has been, this is not a recent thing, the state of Texas has basically determined that student library records are something that can be shared with parents. Okay. Whereas here in Oregon, the sunshine laws are more restrictive. And so the state of Oregon has determined that student library records are not to be shared with parents. They are theirs and theirs alone. So it really, really depends on where you are. And then, of course, we have, COPPA, which limits certain data collection from data. And then we have SIPA as well. So, and then also, like, if you're looking at other terms of privacy, you are also probably most familiar with HIPAA. So it really is a very, like, a crazy mishmash of privacy laws and ideas that determine what is private and what is not when it comes to our students. That was very long. I apologize, but hopefully I made that as succinct as possible.
something that occurred to me when I was looking at this is I was thinking about my own circulation software, which is not special. My own circulation software is not special. But since you mentioned the difference between Oregon and Texas, if somebody came to me, a parent, and said, I demand to see every book my child has ever checked out, the only thing I could tell them is what book they have checked out, as in the book that is currently checked out to that child. So if a book goes missing, it's because it's the book that the child currently has checked out. Can I go back for the how many years that child has been in my school? Absolutely not. There's nothing. I use Follett Destiny, and we only hold on to the information that is currently applicable. What does that child currently have? I don't know what they checked out in middle school or in elementary school. I know nothing about the books they checked out earlier this year, unless you think you're going to pull that out of my brain, which is good luck there. Am I right that this is something, when I created the parameters on Follett Destiny, I said only retain the book that my students are currently checked out. Is that to say that between in Texas, is that to say that Follett Destiny is holding on to every single book that the child checks out? Or how are we controlling what information gets saved so that if somebody can ask for it, it's there or it's not? For me, it's not there, but I'm wondering, are the parameters or the configurations for Follett Destiny set up differently in a library, say, in the state of Texas?
Yeah, so again, it's going to be very, very specific on your school district and your state law. So, for example, in Texas, previous to this, everything was just what the student had checked out, but Senate Bill 13 was just passed in June of 2025, where now all ILSs are required to send emails to parents every time a child checks out a book. Okay, and remember, in the state of Texas, this is allowable because Texas has determined that FERPA does and student library records can be shared with parents. So that is not a violation for that. Okay. But previous to June of 2025, yes, parents would have to request, and whatever we had on hand is what we had, right? What you really need to focus on is if you are lucky enough to have library leadership at the central level, what does their policy say? So, for example, I used to be a library administrator. I held on to just our patrons, like who our people were in our ILS, for 2 years. And we did that because students move in and out, and that way we're not having to worry about duplication of student records from our student data system. But also, seniors, let's say they actually, come back and they're like, oh, I found this book or whatever. We would always hold on to student records, not necessarily checkout records, but there's their borrower accounts for 2 years. However, I moved it from 3 years because in my previous district in Dallas ISD, from what I understood, it was 2 years as well. So it is very, very specific depending on what your library department has decided whenever it comes to data collection. So I know I kind of moved from checkout history to just overall student data, but it really does depend, number one, on state law and how your school district and legal counsel, if you have it, have determined how long to hold on to things. If you are in a district where you do not have central library leadership, this is something you should write into your policies. How long are you going to hold on to data? And this extends also to financial information. So, for example, in my first district in Dallas ISD, I held on to my financial records for 7 years. In my next district, where I was an administrator, I believe we only had to hold on to it for 3 years, is what our legal counsel told us. So again, it is hyper-specific. And if you don't have a policy on that, you need to establish one. Even if it's internal, it doesn't necessarily have to go to the board, but you definitely should, let's say you don't have library leadership, whoever you report to needs to sign off on it and say, this is what we're doing as a district and here is why. Now, if you don't have that library leadership, it can be difficult to facilitate, especially if you're not sure who to go to. But this is really, really important because student data, again, it is private. And despite the fact that the U.S. has a mishmash of privacy and we're not actually a very private country as a rule, we still need to have an obligation to protect our minors to the best of our ability.
Wow. All right. So, friends, it's not unusual that my ignorance is on full display. This is something I have grown accustomed to. I will ask all the questions because I legitimately do not have the answers. And that is one of the reasons why I get so excited when an expert comes on the show, because they have been afforded the opportunity to learn from people. So when I ask these questions, not only do I legitimately do not have the answers, I also expect that there might be somebody else in the listening audience who also is asking the same question and would like me to do this. So for anybody else who is wondering, could you again make the distinction between the checkout records and student data?
So checkout records is something that's going to be decided by school board policy, your legal counsel, if you don't have that, by central administration, and then also your state laws and how they interpret FERPA. Or, for example, like Texas, it's now required that you share that. So it's not just FERPA. In this case, Texas has an extra law on top of it. And then data collection, again, that's still at the local level. That's much more at the local level in terms of data retention. But you should always, always, always have a policy about that, because if you're letting student records hang out into perpetuity, not only does it clog down your ILS, but, school districts get attacked on a daily basis by hackers. You have a minefield of private information. If you are not consistently cleaning up your ILS for that, then you are exposing your students, active students, and alumni. So fun fact, I'm going to go off into a little tangent. I had Michael Johnson, the Olympian from like the 80s or early 90s, can't remember exactly when, but he graduated from Skyline High School in Dallas, Texas. Okay. And so ESPN 30 for 30 called me and said, hey, do you have a yearbook with his picture in it? We'd love to get our hands on that. And I was like, oh, yeah. But I also knew to make sure I knew what I was doing. So I got in contact with the legal counsel, and they're like, oh, by the way, you cannot confirm or deny whether or not any student has ever attended or graduated from your school into perpetuity. Even though it's public record, you as a public education employee cannot confirm or deny. And that is when it told me, that's when I first learned, oh, privacy really means privacy. We cannot share that information, even if it's public record. It doesn't come from us, it comes from the individual itself. So I know that's a bit of a tangent, but this is why it's so important to have a policy about data cleanup within your ILS.
In my school, we have, and I know my school is not unique in this practice, but it is not unusual for us to hire alumni as faculty. So we regularly bring in somebody on the teaching staff who graduated from our school. And I think it's fun, and I that's never been my situation, but I think it's fun. But it is interesting because now that I think about it, when I put in a particular teacher's name into my circulation software, they come up multiple times, and one of the times is as a student, and because there's an S next to it, and there's an F next to the next one, and every once in a while I try and check out material to them, but I realize I can't because that's actually their student record, not their faculty record. And it's like, I don't think this is a good thing. I think this, but again, it would be incumbent on me to reach out to the individuals who are controlling this is outside of my purview, because I do not have that kind of access to actively remove profiles without contacting central office. Yes. And all right. My Monday list has just gotten a lot longer, thanks to you. All right. But I think it is important to mention that, and the history, I'm old enough that I can blame the fact that I love history, but I also lived it. So when the Twin Towers fell in 2001, one of the methods by which the investigators were trying to learn more about the individuals who perpetrated the crime, who brought down the planes, was to track down their borrowing habits from libraries in their communities. And there had been within the week of 9/11, the USA Patriot Act was passed, and it really did, and I included a link in our show notes, but it really opened the door to created a great deal of accessibility where there hadn't been any before when it came to privacy, in the name of trying to provide Americans with some sense of security, that if people were going to the libraries and checking out materials like the Anarchist Cookbook, which I remember when I was in high school, that was behind the desk. If you checked out the Anarchist Cookbook, then clearly you were a deviant, and we had to keep track of what you were going to be doing in your next steps. And I see this as such a window into time, because now the Patriot Act, I don't know how much relevance it has when it comes to libraries, because I don't know if the libraries are necessarily where people are going for their information on how to build the types of bombs. I'm thinking about the pressure cooker bombs that were used in the Boston Marathon, et cetera. They were looking more at user data on their personal devices. That's why they were going after individuals and not just their laptops, but also their phones, and trying to access them. So I don't know, but I'm fascinated only in so much that how we protect our privacy has had to evolve along with technology.
Oh, 100%. 100%.
Yeah. Let's go ahead and start to talk about filters. In my experience, most schools belonging to like a district have filters decided for them by central office. Can you speak to how filters are going to impact what kind of privacy we are affording our students?
Absolutely. So CIPA, the Child Internet Protection Act, is directly tied to filters. So basically, if you don't already know this, and yes, this is 100% determined at the central level, okay? But you should still know what the central level policy is when it comes to applying filters because of CIPA. So the filters are determined usually by the IT department, if you have one. If you don't, you should find out who does. And if you take any E-rate money, which is, if you don't know what E-rate money is, it's federal money that is given to libraries to help provide accessibility with technology and internet. Sometimes it's used for devices. E-rate is basically for technology. And both public libraries and school districts have access to this. If you accept E-rate money, which most organizations do, you are required to have filters because of the CIPA law, okay? So within that, we already know, or if you don't, that's okay. Now you know. Filters is not a one-size-fit-all application, and there is always potential for either underblocking or overblocking, or overfiltering or underfiltering, okay? So we do this because CIPA requires us to block obscene material as defined by the Miller versus California court case in 1973, and then what is considered to be child pornography according to New York versus Ferber case in 1982, okay? And so we have these filters in place to prevent our students from being exposed to pornography. And same thing in public libraries. Now, actually, in school libraries, it's quite easy because all of our community are almost all minors, and there's different filters that apply to faculty. So you have one set of faculty filters, one set of filters for children. Imagine being in a public library where you serve everybody all of the time. So it's really quite a complex issue at the public library level. Hopefully, you know of a way to request that something becomes unblocked. So, for example, I have had to, both as an administrator and as a campus librarian, I have had to request that content be unblocked from a district perspective for my students because, say, someone decided to block the word breast, okay? But we have high school students who are researching breast cancer. and it's blocking content that is perfectly fine. It is authoritative. So I would go and I would request that it be unblocked, and I would give my explanation why. If you don't know what that process is, you should find out, because in reality, filters are not perfect. Sometimes things do slide through. But I think what happens more often is that there is educational content that our students need to have access to that needs to be unblocked. And your IT department can be very, very specific about how that is unblocked. Just because they unblock one thing, say my example, breast, because of breast cancer, they can unblock it for high school students, but continue to block it for all students below that. Okay. And then, of course, with staff, you should be able to do the same thing, even though your filters are more open. And so you really need to, as a library administrator, if you aren't best friends with your IT department, you need to be. If you don't have that central leadership, you need to at least find out what the process is to get things unblocked, and then be prepared for your justification. In Texas, I would always put my student standards that I was using for my lessons, and I've done the same here. I need this unblocked because I'm working with blah, 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 and these are the student standards that this matches. So to save yourself the time, don't just say, I need to unblock because I'm teaching this lesson. Make sure you articulate instructionally why it's necessary and how it supports student standards.
And I don't know if you've been around as long as I have, but I got to tell you, in the early days of the internet, I found my students were being blocked, and this was I briefly taught in a Catholic school, and it was an experience I'm very glad I've had. But it was interesting because I was still in the classroom. I had not yet started my program as a librarian, but my students were coming up against internet blocks for their college searches because one of them wanted to see if they could get into UVA, University of Virginia. And Virginia was blocked. And it got a real big laugh. We were in the library, and I could not figure out what the kids were laughing about so hard. But they were being blocked because they were doing college searches, and apparently the University of Virginia was blocked because of the word virgin in Virginia. And I know that I've been flagged before, back in the early days of the internet. And I was absolutely flagged because I looked up La Leche League. And I was probably 6 or 7 months pregnant, and I was doing detention duty, and I was doing some, what I considered was after school, and I was just, here I am 6 months pregnant with our first child, and I was like, La Leche League, and my screen just went, big red flags. This has been flagged. This has been flagged. And I was like, oh no. And so that I quickly went to my IT department. I was like, okay, please understand. It was, first of all, the fact that it was after school had nothing to do with it. The fact that this was detention had nothing to do with it. The fact that my screen was turned away from the students. But I was like, I've just been red flagged. Please understand. Do not block me. But I'm trying to figure out something. And it was like, whatever. It was so dumb. But I absolutely got a red flag. And I had to then embarrass myself in front of my IT department and explain why I got red flagged. And this makes all the sense in the world if you're, Anyway, it was like my experience going, oh, I guess Big Brother is watching.
Well, and I think it's really important to remember that the filters can sometimes change on a daily basis. Because if you think about it from an IT perspective, they're getting reports all day long from teachers, students all day long. So they will go in and they'll change things that have been blocked. So just because you have one thing that's available one day, if something else has been reported with that keyword, like you mentioned, Virginia, it might be blocked the next day. So just understand that the filters and how they are handled is not like a one and done. It is a very, very fluid thing. And so that's why it's so important to make sure you understand what that process is to get something unblocked for your students so they have access to highly rigorous and authoritative educational materials.
And friends, my ability to understand the law is very limited, and I have a great deal of respect for people who can keep this straight. But you mentioned the Miller test and the serious value test. And this, for me, it was just trying to understand this slide was really revealing, because if you had ever entertained the idea of going to law school, watch how you do just trying to suss out the difference between the Miller test and the serious value test, and see how you feel about, looking at the nuances here. But can you give us a better appreciation and how this applies to student privacy?
The serious value test is actually part of prong 3 of the Miller test. And by the way, I was sitting exactly in that seat that you were in May of 2024, because like I said, we cover intellectual freedom in school library, and it's our master's degree. But when you get into the campus, and unless you have sustained training on intellectual freedom and all of the laws that cover that, you can forget. And I'll be honest, I forgot. So when I was sitting in this training, I'm just like, my mind was blown. So if it's confusing for you, please don't think it's you. It is heady stuff. And again, we're not lawyers. So the Miller test was Miller versus California, 1973, pivotal key court case that basically forms our reconsideration policies throughout the country, because this was a Supreme Court decision. And so basically, whenever we say you have to consider each work as a whole, whenever you are both purchasing and in reconsideration committees, this is probably one of the most important court cases that helps govern that. So basically, if you don't know what the Miller test is, I'm just going to read. There's 3 different parts of it, and I'm just going to read it off real quickly. Please look it up for yourself, and please become best friends, because if you ever have a reconsideration committee, this needs to be your North Star. So the first prong is, does the work depict or describe in a patently offensive way sexual conduct specifically defined by applicable state law? So you have to look at your penal code, which can vary from state to state, in order to be able to evaluate if the work depicts or describes sexual conduct in a patently offensive way. So Texas Penal Code is very specific about what this is. It is not general at all. I can't speak to other states, as I'm still learning Oregon's, because I've only been here for a few months. But look at your state penal code and really, really look at that verbiage. So those of you, so I'm going to go off into all sorts of different things. Those of you who sometimes make decisions about, say, if you're a high school librarian and Follett has flagged something as mature content, when you are looking at that label, you need to evaluate it as a whole, not by a page, not by a paragraph, not by a scene, okay? And you need to make sure that the whole entire book is patently offensive according to your state penal code in its entirety. You cannot eliminate, should not eliminate, based off of a passage, okay? Number 2, would the average person, and this is really important, applying contemporary community standards find the work as a whole appealing to the prurient interest? I love prong 2 because the word or the phrase average person, contemporary community standards. There have been so many districts and states who have been like, well, our local community standards say that you can't allow this and this and this. They are completely misunderstanding that prong. Average person, contemporary community standards applies to the nation as a whole, not what's happening in your community. Okay? So yes, as a librarian, you absolutely should be tuned into what your community needs. Yes, you should absolutely be tuned into your professional reviews that talk about what is grade appropriate, okay? But what is considered to be community standards and what an average person thinks is okay and appeals to the prurient interest does not depend on you and does not depend on your school board and does not depend on your community. It is a national standard, and we already know how diverse this country is. So just because your community doesn't like it doesn't mean that you should necessarily eliminate it. Now, if you use collection development, as we know, is deeply complex. And if you're doing it with full fidelity, it is hours of work. It is so much work. And I'm very empathetic to that. But when you zoom out and you think about the application of the Miller test, this is the standard that we should be applying. It's not about you and it's not about your community. Is it, as a whole, appealing to the prurient interests of the national community? Okay. Now, prong 3, which is where we bring in the serious value test. Does the work taken as a whole? Second mention that the book must be taken as a whole, or the work can be a database too, can be an article, can be a video, whatever it is, a library material. Does it lack serious literary, artistic, political, or scientific value? Okay. So once again, we see school boards and district administration misinterpreting what lacks serious literary, artistic, political, or scientific value. Okay, so the serious value test here was defined in the Miller test. People still had a lot of confusion about what literary, artistic, political, or scientific value means. So then you had a second lawsuit, Pope versus Illinois, in 1987, that established that the serious value test does not vary from community to community. This is where we go back to prong 2. It is according to the nation at large, okay? So this is where it further strengthens that you cannot make an arbitrary decision as a school board about whether or not something lacks serious literary, artistic, political, or scientific value. And why is that? Because you have the educational suitability that school districts don't have to worry about, because educational suitability, who determines if it lacks literary, artistic, political, or scientific value? It's a court of law. It's not on us. It's the court of law. Only a court of law can determine if something lacks the literary, artistic, political, or scientific value. And how do they do that? They do that by calling in a panel of experts into the court. So panel of experts can be a professor of library science. It can be an English professor. It can be a school library administrator. It can be a librarian. It can be an English teacher. So people who are experts in literature are the experts that a court of law will usually come in and ask to evaluate whether or not the work that is being debated lacks literary, artistic, political, or scientific value. So the Miller test, if it's being followed, once again, federal law, is very definitive in how to determine whether or not a book should be removed, or whether or not in your own collection development policy, when you're thinking about soft censorship and your community and trying to be objective as possible, taking your personal viewpoints and take them off the shelf. It's very, very strong in what can be added to your collection.
This just makes me, when I realize the criteria, it makes me wonder why any district would be allowed to ban a book that has won the Nobel Prize for Literature. Why books that have received national and international recognition are also being banned. I'm thinking about Toni Morrison, because as somebody who now at the high school level, I'm making my way through as much Toni Morrison as I can, because, shocker, I was not an ELA teacher. I was a social studies teacher, and my literary background is not nearly as deep, and I clearly am not as well read as I would like to be. But when I look at how many books have received national and international recognition and then are on banned book lists, it boggles my mind. I was like, wait a minute. These are books which have been evaluated at a national and international level and have been awarded for what they bring to literature and to enrich their readers' lives. And it has been done so on a national and international scale, and yet this community here has decided that this book is corrupting their youth. And it's a head scratcher. I'm sorry.
Well, and I'll tell you why that is. So if you don't already know this, laws are only as good as they are enforced. We can have laws, and really our laws by a part of humanity largely depend on our willingness to be compliant, right? Because everything, should you break a law, has to be enforced in a court of law. And our court system is purposefully quite slow. And on top of that, whenever you see a school district who has employed their own community standards and are actively violating the First Amendment rights of their students by specifying protected classes of people. Okay, that's illegal. That's 100% illegal. Doesn't matter what your state law says. Federal law trumps state law. But the reason why is we need someone to go through the court system and sue. And teachers can't do that. Librarians can't do that. Employees can't do that because they're not the ones who are actively being harmed by these First Amendment violation of school board policies and, for in Texas' example, state law, because no one has gone through the court system and sued. And it has to be a family that has actively students in that system, ideally someone who has students of varying ages, because once again, our court system is very slow. And your families are the ones that have to say, my student, my child's First Amendment rights are being violated. And by the way, if you don't know much about First Amendment protections with the current SCOTUS, only Justice Thomas has it in writing that minors do not have First Amendment protections. He is the only one on the Supreme Court who has said that. But Justice Alito has actively in writing said that once you eliminate the intellectual freedoms of one group, it's a very slippery slope. So the way that reads is that Justice Alito is in favor of intellectual freedoms for our students and for everybody. So I find that personally very comforting when I think about all of the intellectual freedoms and all the First Amendment violations are happening throughout the country for our students, is that at least with the Supreme Court, they've not yet heard it, but there are tons and tons of laws that are currently in district courts. And we'll see if any of them go to SCOTUS and see if they will hear it.
All right. I have to ask, you have a slide, best practices for SIPA compliance, but do you want to identify these things?
No, let's go ahead and go through it because I think it provides it in a succinct list.
When you say best practice, I'm like, ooh, this is important. All right. So friends, I'm a big fan. Anytime somebody brings it down to the key concepts that we need to retain here, when somebody says best practices, so would you please identify what are according to your training, the best practices when it comes to SIPA compliance for us at our school districts specifically?
All right. So you want to have transparent filtering policies that are posted and accessible. Now, as school librarians, we most likely don't have access to that. But if you have that relationship, you can at least find out if someone asks. I mean, I don't know if a parent will ever ask, but a parent might. You never know. Just about anything happens anywhere. So if a parent asks what the policies are, you should at least know that you can go to your IT team and they should have it posted publicly. You need to have a process for adults to request temporarily removing filter, whether it's for yourself or your students. We did cover that. You need to review those filters periodically to provide access to lawful information. So this, again, is kind of embedded into that process of how you can get something unblocked. I feel that if you are on top of that and you are reviewing those filters that come through, again, they can change up to a daily basis. That meets that criteria, in my opinion. Avoid blocking categories unless required by law. So right now, I feel like most states' penal codes definitely prohibit pornography. And if you look at the Texas Penal Code, it is very specific about what is pornographic content. So you don't want to block categories of things unless your law explicitly says it has to be blocked. So I'm not going to go into specifics, but part of the Texas Penal Code is so very specific about bodies and movement. I'll just put it that way. So in that case, you might be able to block that entire category of what that part of the penal code describes. Okay. But if it doesn't describe it, you shouldn't block it. Definitely need to train staff on handling questions or requests about filtering. So no, you're not the one in charge of it, but do we have teachers saying, hey, do you know why this is blocked? Yeah, we do. I've often had people who have ask me, hey, do you know why this is blocked? Okay. So again, making sure that communication channel is open to your IT department so that you can help inform others. And then if you as an entity, and I'm speaking to my library leaders out there or lead librarians, whatever that might look like, if you're working with your IT team and you're determining whether or not you want to apply for the E-rate discounts, this might apply to our charter schools, our private schools. If you decide not to apply for it, SIPA doesn't apply to you because you are not accepting that. Well, it does apply to you, but you don't have to worry about SIPA as firmly, but you definitely need to figure out what are some alternatives in place of filters because, again, at the end of the day, your IT department is still responsible for making sure that your children are not exposed to pornographic content.
So when you were trained, this also expanded not just to our use of the internet, but also social media. Can you spend a little bit of time giving us a rundown of how this impacts us and the job we do?
Yes. Okay. So this to me is is a whole nother 1 hour, 50-minute presentation at a state conference. I could talk about this all day. But yes, social media usage. Okay. So we know that if you have a school account, your own personal account, if your students and their parents, guardians, or caretakers have not given permission for their photo to be shared, we know we can't post that. And policy changes from district to district about what is acceptable. Some people do not allow any pictures at all, and no, an emoji over that student's face absolutely does not count. You cannot post anything at all. Others say, yeah, go ahead and put an emoji over it. That's perfectly fine as long as you cannot tell who the student is, including from the back. So even if you have the back of student heads, I always went an extra step and put an emoji over that as well. And any distinguishing clothing or backpack, I always cover that up. So we know that. But when it comes to, say, communicating with students, need to look at your board policy. Board policies can be, I have seen the gamut from being hyper specific about when you can communicate with students via social media to almost no guidance at all. So I've worked in districts where there were specific hours where you could communicate with your students via any type of communication, including social media. Obviously, do not follow your students back. That's inappropriate. That may be outlined in your school board policy. It may not be, but I certainly feel best practice. You should never follow your students back because, especially for those younger students, they cannot consent to their own usage of social media. Only their parents can. And then with our high school students, again, just best practice. We got to keep it professional. That's a student. I don't need to know that about your life. You can follow me. We kind of talked about the student angle. Let's talk about personal usage of social media when doing school library content. I always recommend that you keep your own personal social media accounts private and not for school use. I recommend that if you are allowed to have a social media account, that you make it a school one, and that's the only one that you use. So for example, I currently have 3 accounts. I have my personal, which is my friends and, people that I'm close to. I don't mind them seeing things about me, who I am. I have my personal professional one, which is my PLN. That's where I connect with librarians and I'll post things about things that I'm personally doing. And then I have my school account where I post about what my students are doing, what things are happening in the library, and I do not cross over. So for example, on my school library account, I don't like news posts. I don't share news posts unless it is specifically about librarianship. Okay? And I do that personally. If I want to post something about librarianship that is broader than my school, that's when I go to my PLN account and then I'll go ahead and choose and share news articles and posts and things like that. Okay. When you have a school social media account, it is public. You cannot block anybody. You cannot make it a private account because as soon as you create an account that is affiliated with your school, you are now a public entity. So if someone is harassing you, you can mute them, but you cannot block them. You need to go to your administration. If you have an open channel to your communications department, and that's something that is accepted, you don't have to worry about chain of command stuff. You need to reach out to them as soon as someone is saying inappropriate things or harassing you or sending messages or commenting on your posts, including students. That must be reported so that you can find out what your communications and your legal counsel decide on how to handle that. So I've had a few instances where I've had to report that out, and I've been given guidance by my legal counsel on how to do that. But you absolutely, and oh, by the way, you can't delete comments either. That's public record. Okay? Anything on your school account is public record. So that's why it can never be private. You cannot block and you cannot delete anything. So all of that is discoverable by the Freedom of Information Act, which has various terms. Some districts call it open records request. Some people say public information request. everything that you do on your school device, everything that you do on school time, everything that you do through your email, your documents, your lessons, and your social media. It is all open and available to the public. They can do that anytime, including your cell phone. So if you use your personal cell phone and you are texting with your colleagues about school-related matters, technically speaking, someone can ask for your text messages if you use it for school, and you have to release this. And it has happened to several of my colleagues. So you have to be very purposeful in what you utilize your school accounts for, as well as your social media account. Yeah, I think that I've pretty much covered that. It's pretty intense when you really think about it.
All of a sudden, there are a lot of folks going, wait, did I have that conversation with you were we texting? So I'm sitting there going, a lot of my colleagues reach out to me via text because I work in a building that's massive and I am nowhere near my phone ever. I'm nowhere near my computer ever, because I am moving between rooms and doing triage because somebody needs this. I'm responsible for the copy machines because apparently that's part of my job. And, I'm rarely sitting at the phone waiting for somebody to call me. So if people, just for people who might be wondering, you just said your phone records could be,
Yes.
Okay. So if I am friends who text with colleagues and we are back and forth texting, and that is all something that could be, requested in a legal situation?
Yes. If you're talking about school-related matters, if you're talking about a student, first of all, you should never, ever put a student's full name in any text messages. That's a privacy violation. But yes, if you use your personal phone for school business, yes, it is subject to a FOIA. So you need to think carefully. That's why as a library administrator, and I think a lot of people understand this. If there was a sensitive conversation and someone had asked me a question, I'm going to call you. Because if you need to ask questions that are difficult and complicated, and you're scared of having your words misrepresented, which happens and has been happening for a few years now, pick up the phone and call me. Or I'll pick up the phone and I'll call you, and we'll work through this. So, if it comes to privacy where you're talking about students, it's probably best to have that conversation person to person, because you don't want to accidentally share information about that student that is now open to the public. Now, technically, yes, of course, your communications department is going to go through and protect that student's privacy, but I still think that as a holistic approach to how I am comporting school business, I still think it's best to remember that privacy is always at the front and center. And it's really easy to forget that, especially when you work in a large school, or let's say you have several campuses, right? We have librarians who serve several campuses. How are you going to be able to continue to do the job that you need to do without accidentally violating the privacy of your students?
Well, and let's back up just for a quick minute, because you mentioned FOIA. And can you just break this down? Because what we've done, we've moved from, this, for those of us who are just like mind blown right now, because I'm sitting there thinking, no, this is my personal device. And if I'm having a private conversation with a colleague, the fact that I'm not using my school, in my stupidity is on full display, friends. If I am at my work computer, I make that distinction between communications on my work computer, because this is something that's been provided to me by my employer, versus the phone that I purchase with my money and a data plan that I pay for. And you're telling me that the rules do not make a distinction here at all.
That's correct.
This is not welcome information. I'm sorry.
No, I understand, but I think that's why this conversation is so important. And I would always advocate for sustained training within school districts about what privacy really means, because FERPA, the little compliance video that you may or may not do as a requirement for your school district, it's always been required for all of mine, is not enough. It's simply not enough. FERPA is a good place to start, but there's so much more when it comes to librarianship that we are beholden to in our practice and protecting our students.
Yes. Oh my goodness. Heather Hornor, you are a font of expertise, and I am so grateful that you were picked to attend and participate in becoming one of the librarians who is training the rest of us on how to do better when we know better. And thank you so much for all the resources that you have provided for us. There's so much we could go into with greater specificity, but and especially when it comes to student privacy and FOIA. But, this episode's coming out on March 20th, but March 16th stands out, and you said for a funny reason, but I'd love to know, can you go into specifics as to why March 16th is related in this conversation?
I would love to. So March 16th is President James Madison's birthday, and it is Freedom of Information Day. And James Madison was a staunch proponent of privacy of the individual. If you look back at his writings, you'll see that he's probably one of the other people that we kind of started cobbling privacy from, and the idea of privacy for us as a new nation. And so we celebrate that. And it was established in the 1980s. And so basically out of that, we celebrate the Freedom of Information Act because we as citizens and residents have permission to have oversight of what our government does in our name. And so we celebrate March 16th for that very reason. And I always think, now that I've been trained, I've been lucky enough to be trained because I love this stuff. And I didn't know that I did until I got trained. But if we as humans and librarians benefit from having a refresh on the importance of privacy and how it moves in our society and how it impacts each and every one of us, why not teach our students the rights that they have? If we haven't thought about doing that other than just book access, let's teach them about how they have the right to hold their government accountable and to find out information. And that means all levels of government, from local all the way up to federal. And so I happen to be the chair of the School Library Event Promotion Committee, and we have worked very, very hard. I have wonderful committee members. Please go in the AASL member connect space. I outline all of the members of the committee because they're all awesome. We have some resources for you for not only professional learning, but also book lists that you can promote and learner engagement activities that you can utilize with your students. And hey, yes, this is coming out after March 16th. But you can plan for next year. Or maybe you still have time to fit something in before the end of the school year. But use this stuff. This stuff stays up all year long. And you can plan to celebrate that day. Even if you are in a state with highly restrictive, illegal state laws that are happening or board policies, that still doesn't negate the fact that the Freedom of Information Act is a powerful thing, and that you can use it and you can teach your students about their power to use it as well. And I just think that's so important to be able to empower our students and help them understand, again, this is civics. This is our country. We have a responsibility to help empower our students to utilize it.
I love this emphasis on the word information, because I was very aware between the time I got my library science degree and now that so many of our library schools have rebranded as information schools. If we embrace this word I as in information, I tell people I'm an information specialist and I have a degree in information science. But that also applies to this idea of information in the context of the Freedom of Information Act. And we don't get to draw the distinction as being information specialists and not appreciate what this also means when it comes to our responsibilities and our rights to the information that we come into contact with.
I agree.
Fantastic. Well, I'm so grateful that we've been able to tap your expertise, and I know that our paths are going to cross again in the future, but definitely remind us, what is the best way to reach out to you if we want to connect?
I am on Blue Sky. I am also on Instagram, and I'm on LinkedIn should you choose to connect there.
Fantastic. We'll put those links in the show notes. Heather Hornor, have a fantastic next week. By March 20th, when this episode comes out, we're going to be well into spring. I can't wait. All right, Heather, thank you so much, and I'm excited to connect with you in the future.
Thanks again for having me and letting me talk about something I love to talk about.
Friends, if you found this episode helpful, please share it out with your team, your PLN, and on social media. Be sure to follow on your favorite podcatcher so you'll never miss an episode. And if you really like listening today, consider leaving a review wherever you listen to podcasts. Reviews help others find us. If you're curious to know how often your state or country has been featured on the podcast, simply click on the link which can be found in our show notes, search title, author, state, and country, and do a Command F search. I hope this is the year you consider being a guest on the show. Please visit the FAQs in every episode and you'll realize just how easy it is. We all have something to share. Make 2026 your time to shine. The topic of our next episode is Revolutionize Youth Book Clubs and my conversation with Stacey Brown. I hope you will tune in.